Welcome to this deep dive. Today, we are unpacking a fascinating, highly complex legal puzzle for you. To get us started, think about buying a gift card for a friend.
Right.
You hand your money over to the store, and in exchange, they promise to give your friend coffee or books or whatever it is. If the store suddenly refuses to honor that gift card, your friend can certainly complain. But you also have the right to demand the store honor the deal, right? Because, it was your money. You paid for that promise.
Exactly. You hold the consideration.
Yeah. Now, scale that up from a $20 gift card to a multi-million-dollar estate, and imagine the person who bought the promise has passed away. That is the exact scenario we are looking at today. When you make a binding contract to benefit a third party and you die, does your estate have the right to enforce that promise, even if your estate doesn't stand to get a single dime from it?
It is a really profound question about the philosophical limits of contract law. To answer it, we're going to trace a very specific analytical path today. We will guide you through the foundational doctrine of third-party beneficiary contracts, looking specifically at the unique rules governing contracts to make a will. From there, we will dissect the legal standing of a promisee versus a beneficiary. And finally, we'll examine the equitable remedies available when these highly personal agreements are breached.
Sounds like a solid roadmap.
By the end of this, you will have a comprehensive understanding of how the law protects a promise you bought and paid for, even from beyond the grave.
Okay, so the law ostensibly respects the bargain, but that leads to an obvious problem. How does a dead person enforce a bargain? Let's ground this in reality. How exactly does the law handle a situation where someone promises to structure their will a certain way as part of, say, a divorce settlement, but then secretly changes that will years later?
That brings us directly to the general rule regarding third-party beneficiary enforcement and promise rights. The law dictates that a person can legally bind themselves by contract to make a particular will.
So it's not just a polite intention.
Right, it is an enforceable bargain. Furthermore, the rule states that a promisee, the person who negotiated and gave up consideration to secure that benefit for a third party, has a fundamental right to enforce that bargain. The law recognizes that the promisee has a distinct, protectable interest in seeing the contract fulfilled.
Regardless of who gets the money.
Exactly. Regardless of whether the ultimate financial payout goes to them or to the third party.
To see how courts actually untangle this, we need to look at a landmark decision from the New Jersey Supreme Court. Let's analyze Drewen v. Bank of Manhattan Co. First, what are the legally dispositive facts?
The facts here unfold chronologically and set up a classic, almost cinematic familial conflict. Back in 1917, Doris and Stanhope Nixon were married. They eventually had 2 children, Louis and Blanche. Decades later, in 1945, anticipating a divorce, Doris and Stanhope signed a comprehensive settlement agreement. As a core part of that settlement, Stanhope explicitly promised that his final will would leave their 2 children, Louis and Blanche, approximately 30% of his estate in fee simple. That means absolute ownership of the assets with no strings attached. He even executed a will that very same day reflecting those exact terms.
I am guessing Stanhope didn't stick to the deal.
You would be right. Fast forward to 1948 and Doris dies in California. An administrator is appointed to handle her estate. Then in 1951, with his ex-wife out of the picture, Stanhope makes a highly calculated move. He executes a completely new will, entirely revoking the 1945 terms.
Wow.
He drastically reduces the children's shares. Instead of fee-simple ownership, he gives them mere life estates, meaning they only get the income generated by the assets during their lives, not the underlying property itself. He gives the remainders of those assets to charity. And, most aggressively, he adds an interim clause.
Just to clarify, for anyone who hasn't encountered one of those in the wild, an interim clause is a provision stating that if anyone challenges the validity of the will, their entire inheritance is completely voided.
Exactly. It is a legal landmine. In 1955, the daughter, Blanche, dies without having any children. This leaves the son, Louis, as the sole surviving heir who would succeed to her share under either of the father's wills. Then, in 1958, Stanhope finally dies. His 1951 will is admitted to probate, and the Bank of Manhattan Company is appointed as the executor. Seeing this blatant violation of the 1945 divorce settlement, the administrator of Doris's estate, a man named John Drewen, sues Stanhope's executor to enforce the original 1945 contract.
Right, and technically Drewen is an administrator CTA, which basically just means he's managing Doris's estate with her will attached, stepping in to make sure her final wishes and contracts are actually carried out.
Precisely.
But wait, If Lewis sues his father's estate to get the 30% his mother fought for, he risks triggering that interim clause and getting literally nothing. That is incredibly vindictive. It completely corners the son. And what was the core legal issue?
The precise issue before the court was this. Does the administrator of a deceased promisee's estate have standing to sue for breach of a contract made for the benefit of a third party done, even when no financial benefit will accrue to the promisee's estate?
What rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements.
The court applied this black-letter rule. A promisee of a contract for the benefit of a third party done has a sufficient interest in the enforcement of the promise to entitle them to sue for damages or invoke equity.
Okay, and the elements.
The rule has 4 elements. First, there must be a valid contract to make a particular will. Second, there must be an intended third-party beneficiary. Third, there must be a promisee who bought and paid for the promise. And fourth, there must be an inadequacy of a remedy at law justifying equitable relief.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, a valid contract to make a particular will?
Let's look at the sub-issue here, which asks whether an individual can actually restrict their future testamentary freedom by contract. Wills are generally ambulatory, meaning you can change them right up until you die. But the sub-rule the court relies on dictates that it is beyond question that a person may legally bind himself by contract to make a particular will.
So they looked at the settlement.
Right. When the court looked at this, they zeroed in on that 1945 divorce settlement. Stanhope didn't just casually mention his intentions. He explicitly promised in writing, as part of a formal legal separation, never to reduce the quantity or quality of the children's interest in his estate. He locked himself in. Because he memorialized this obligation in writing, supported by consideration, the court concluded that this first element, a valid contract to make a particular will, was definitively met.
Understood. Now, what about the second element, an intended third-party beneficiary?
The sub-issue for this second element asks who the actual beneficiary is and what rights they hold under the contract. The relevant sub-rule dictates that an intended third-party beneficiary can absolutely maintain a suit for specific performance to enforce a contract made for their benefit.
Which would be Lewis.
Applying the facts, yes, Lewis Nixon, the surviving son, is the clear, unambiguous intended beneficiary of that promised 30% fee simple share. This wasn't an incidental benefit. The whole point of the clause was to protect him and his sister. Now, the defense Stanhope's executor tried to use this against the mother's estate.
How so?
They cited a specific New Jersey statute and argued that only Lewis could sue, claiming the right belonged exclusively to the beneficiary. But the court systematically rejected that exclusivity argument. The court noted that while the beneficiary certainly has rights, the promisee and the beneficiary can have distinct, concurrent, enforceable rights in the exact same contract. Thus, the court concluded this second element was met, noting that the existence of a third-party beneficiary does not automatically extinguish the promisee's rights.
Moving on to the third element, a promisee who bought and paid for the promise. How did the court handle this?
This is where we get into the real heart of the controversy. The sub-issue here is evaluating the promisee's standing when their estate stands to receive absolutely no direct assets from the lawsuit's success.
Because the money goes to Lewis.
Exactly. If the lawsuit wins, the 30% goes to Lewis, not to Doris's estate. So why should Doris's estate be allowed in the courtroom? The sub-rule applied by the court states that a promisee has a sufficient legal interest to enforce a promise that they bought and paid for.
And Doris definitely paid.
Looking at what happened, we have to recognize what Doris sacrificed back in 1945. She didn't just ask Stanhope for a favor. She gave up her own tangible property rights and marital claims during a contentious divorce settlement specifically to secure this inheritance for her children. She purchased that promise. When she died, her estate administrator stepped directly into her legal shoes.
So the lack of a financial payout doesn't matter.
The court firmly concluded that this element is met. The defense argued that because Doris's estate wouldn't financially profit from the lawsuit, they had no standing. But the court declared that the lack of direct financial realization for the estate does not strip the promisee or their representative the right to get exactly what they paid for. She bargained for a specific outcome, and her estate has the right to see that bargain fulfilled.
And finally, the fourth element, the inadequacy of a remedy at law justifying equitable relief. How is this applied?
The sub-issue for the final element centers on determining the proper remedy for the breach. Can we just award money? or do we need the court to force an action? The governing subrule states that equity will afford relief because traditional legal remedies, like a basic award of money damages, are inadequate. Furthermore, breaching a contract to make a will is legally deemed a fraud against which equity must afford relief.
That is the trap.
Applying the facts, we see exactly why simple monetary damages fail completely here. As you pointed out earlier, Stanhope's sneaky 1951 will was a booby trap. He included that interim clause. If Lewis tried to sue his father's estate to enforce the 1945 contract, he would trigger that clause. He risked challenging the will and ending up with absolutely nothing if he lost. Lewis's hands were completely tied.
So writing a check to the mother's estate doesn't solve Lewis's problem.
Simply awarding damages to the mother's estate wouldn't fix this precarious position for the son, and it wouldn't put the 30% fee simple where it belonged. Therefore, the court concluded that a remedy at law is utterly inadequate, and equity is absolutely required. A court of equity must step in to force the specific performance of the 1945 terms, effectively bypassing the trap Stanhope laid. This fourth element was firmly met.
And after analyzing all the elements, what was the court's final conclusion?
Synthesizing the elemental analysis, the Supreme Court of New Jersey decisively reversed the lower courts. Both the Chancery and Appellate divisions had initially dismissed the case, buying into the argument that only the son could sue. But the Supreme Court's ultimate holding was that the administrator of the promisee's estate definitively has standing to prosecute the suit and invoke equity to enforce the contract, ensuring that the promise Doris bought and paid for was actually honored.
Okay, let's test this with something a little weirder. Imagine two people, a donor and a collector. The collector has a prized, incredibly gross collection of human appendixes, all preserved in cloudy glass jars.
Gross. Okay, I'm with you.
Right. So the collector promises to give this entire bizarre collection to the donor's nephew, who is our third-party beneficiary. In exchange for this, the donor agrees to pay for the collector's highly illegal underground taxidermy lessons. The deal is struck, the donor pays for the lessons, but then the donor dies. Now, the collector refuses to hand over the jars of appendixes to the nephew. The collector argues, hey, only the nephew can sue me for this, and the nephew is way too disgusted by these jars to ever set foot in a courtroom. So under the rule we just learned, can the donor's estate sue the collector to force the transfer of these gross jars?
If we connect this absurd scenario to the bigger picture and apply the Drewen rule, the answer is a resounding yes. The donor's estate can absolutely sue the collector. Let's break it down just like the New Jersey Supreme Court did.
Yeah.
The donor bought and paid for that bizarre promise by funding those illegal taxidermy lessons. Because the donor paid the consideration, the donor's estate now steps perfectly into the promisee's shoes.
Even for jars of appendixes.
The estate has a legally recognized sufficient interest to enforce the transfer of those jarred appendixes to the nephew. It is completely irrelevant whether the estate itself financially benefits from the jars, which, let's be honest, they wouldn't, or whether the nephew is too grossed out to sue on his own behalf. The estate is enforcing the bargain that the deceased donor made. The law focuses on the integrity of the contract, not the objective value or desirability of the appendixes.
Which brings us to you, the listener. You might be wondering, why should you care about human appendixes, or 1940s divorce settlements, or arcane probate rules? The ultimate takeaway here is that contract law isn't just about who gets the money, it is about the right to get exactly what you bargained for.
Precisely. Doris didn't buy money. She bought peace of mind. What's fascinating here is that this doctrine protects the most fundamental human desires we have. It protects our desire to provide for our loved ones. Think about it. When you negotiate a benefit for someone else, maybe you sign a contract paying for a family member's college education, or you secure your child's inheritance during a difficult divorce, you are giving up something of yours to help them.
You are making a sacrifice.
The law is saying that your right to see that promise fulfilled does not just evaporate into thin air simply because the ultimate payout goes to them instead of you. Your intentions, your negotiations, and the sacrifices you made matter. This rule ensures that your protective reach extends beyond your own direct financial gain, and remarkably, even beyond your own life.
That is a powerful realization. It makes the mechanics of the law feel much more human. If you're staring down a fact pattern on a final exam with a scenario like this, your instinct might be to just look at the beneficiary. But how should a student actually structure their analysis to avoid falling into the same trap the lower courts did in Drewen?
To ensure you can apply this practically, let's transition into synthesizing everything we've covered into a step-by-step diagnostic checklist. Use this 4-step framework for issue spotting complex contract disputes. Step 1. Identify the parties. Don't just skim the names. You must clearly map out the players and their roles. Who is the promiser making the guarantee? Who is the promisee giving up consideration? And who is the third-party donee beneficiary standing to receive the ultimate gift? Keep their legal interests distinct in your mind.
Good. Step 2.
Step 2. Identify the breach. Look closely for a subsequent act that violates the original contract. In our case study, it wasn't just a failure to pay. It was an affirmative, sneaky act, a newly executed will that directly contradicted the settlement agreement and included a punitive interim clause.
Right, the booby trap.
Step 3. Analyze standing. This is where most people fail. Remember the crucial trap. Defendants will almost always argue that only the third party can sue, trying to isolate the beneficiary, especially if the beneficiary is compromised or terrified of a legal trap. You must apply the rule that the promisee or their estate administrator also has standing because they bought and paid for the promise. The rights are concurrent.
And the final step.
Step 4. Determine the remedy. Evaluate if a remedy at law, meaning standard financial damages, is inadequate. If the breach involves a contract to make a will, or if the beneficiary is trapped by an interim clause, damages will not fix the problem. You should classify the breach as a type of fraud against the promisee's intent. In these cases, equity will step in to offer specific performance, forcing the breaching party to actually do what they promised, rather than just paying a penalty.
That is exactly the kind of framework that cuts through the complexity. We have covered a lot of ground today, from the technicalities of an administrator CTA to the equitable remedies needed to bypass a vindictive interim clause. Thank you for listening and following along with this rigorous deep dive into the Nixon family's legal battles and the enduring power of a promise. But before we go, I want to leave you with a final provocative thought to ponder on your own. We have firmly established today that a promisee's estate can aggressively step in and force the fulfillment of a gift to a third party. But what happens if that third-party beneficiary actively rejects the benefit?
That's a great question.
If the estate spends time and money suing to enforce the contract, but the beneficiary flat out refuses to accept the inheritance, maybe they don't want the money, or maybe they really truly don't want those jars of appendixes, who wins the ultimate battle over a forced gift? Does the estate get the value back? Does the promiser keep it? It is a fascinating collision of contract law and personal autonomy. Until next time, keep questioning the fine print.